Good morning, everybody, all the dignitaries, advocates, and my beloved youngsters. As you know, this webinar series is dedicated for the advocates who have a quest for knowledge. And this webinar series never compromises on the topics and the resource person. Today's resource person is Mr. Sai Deepak. He is an engineer turned lawyer. His bachelor's degree in law from IIT Kharagpur in the year 2009 was preceded by a degree in mechanical engineering from Anna University, Chennai in 2006. Sai has been a litigator since 2009 and was an associate partner in Sai Krishna and Associates till 2016. Sai founded an independent law firm and set up independent practice in the year 2016. His appearances is expansive that includes the Supreme Court of India, High Court of Delhi and Madras, Competition Commissions of India, NCLAT, and IP Appellate Board. He specializes in the areas of civil commercial litigations, IP litigations, information technology laws, competition law, indirect taxation, and his homegrown constitutional law. His arguments on behalf of ready-to-wait women campaigners in the Sabarimala Ayyappa temple dispute and before the Supreme Court of India deserves a special mentioning here. Department of Industrial Policy and Promotion, functioning under the auspices of Ministry of Commerce, Government of India, engages Mr. Sai Deepak as honorary advisor on the implementation of the national IPR policy. And another laurel in his credit is Sai Deepak was one of the 19 alumni of IIT Kharagpur who were awarded the Young Alumni Achievers Award in 2019. I'm very happy and delightful to have Mr. Sai as a resource person today. With this warm introduction, I hand over the forum to Sai. Mr. Sai, please take over the floor.
Thank you, sir. Thank you for this warm and kind introduction, and I'm grateful to the organizers for giving me an opportunity to engage with the enlightened members of the Madras Bar. I have had an opportunity to appear before this August court on many an occasion, and I seem to be making a frequent visit to Chennai once in a month at the very least, not in the least to visit my in-laws, but my other in-laws, that would be the High Court. So
it's nice.
The building itself has an old world feel to it, and I love the way the courts maintain some of their traditions. So I'm very happy to be engaging with members of this bar. One thing that I had proposed to Mr. Raghavan, and he was kind enough to agree to that, is that over the last few months I've tried to change the style of my presentation to make it more interactive, because I feel that a one-way monologue or a lecture is not perhaps the Indian way. The Indian way is question and answer, which is prashnottar. So that's my way of going about it. So I'm going to try and give as brief and as concise an introduction as possible to the topic, to try and address certain high-level issues, which I have encountered over the last, I think, 5 or 6 months whenever I've spoken on this particular topic. And I'll then request members of the audience, the participants, to share their questions with me, either through Mr. Raghavan or even on the chat box, and I'll try to answer as many questions as possible. A nugget of information, and this is not self-edificatory. I'm fairly good when it comes to question and answers, and usually the Q&A sessions of my talks happen to be much more interesting than my so-called monologues themselves. So please make the most of this opportunity and throw whatever you can at me. As long as they are relevant to the topic, I'll try and answer each of those questions to the best of my abilities. One of the reasons that I chose to address this particular topic on CAA, NRC, and NPR, when Mr. Raghavan gave me the choice of topic, is that because I felt that this issue, for all practical purposes, to a significant extent, has remained an issue which has traction to the north of India as opposed to the south of India. For some reason, its all India implications have not become that apparent. Perhaps because we assume that the question of illegal migration or the issue of refugeeship is largely limited to certain parts of the country and certain specific states to the north of the country. So that's one of the reasons that I felt that this issue should be discussed as actively as possible across the country. I've made an effort to discuss this issue with members of the Hyderabad Bar. I've discussed this with members of the Karnataka Bar and other places as well. So I think one of the cities which I would say has always qualified as the intellectual capital of Southern India, which is Chennai, it's high time that this issue was discussed threadbare. If there are aspects of my talk which appear political, you will have to pardon me, and because there are certain aspects as far as this particular issue is concerned which can't be entirely constitutional. My attempt is going to be to limit the scope of this discussion as much as possible to the constitutional aspects, but wherever there is an incidental overlap between, let's say, political aspects of the issue and the constitutional aspects, I will necessarily have to traverse those aspects as well. So that is something that I want the audience to be aware of, and I'm known to exercise my right to free speech to the hilt in most of my talks. So if I offend or shock or hurt someone, to put it in the language of Gautam Bhatia's book, I would say that I have done justice to my freedom of speech, freedom of expression. So with that short background, let me get into the topic. I'm going to assume that members of the audience, since most of them come from the legal background, are already aware of the provisions of the Citizenship Amendment Act of 2019 and are aware of the provisions of the Citizenship Act to some extent, and the NRC rules as applicable to Assam, the rules under which these rules have been prescribed, and the provisions of the citizenship rules of 2003, which relates to NPR as well as NRC. Now, let me try and first of all address high-level issues with respect to citizenship, refugeeship, and then come to each of these specific branches and try and connect them in as lucid a manner as possible. One of the things that has happened over the last 5 or 6 months, whenever I've addressed this topic, is I've faced this question of whether the CAA violates Article 14 and whether the CAA is fundamentally discriminatory, whether the CAA has any bearing on the minorities, religious minorities who live within the borders of this country as legitimate citizens of India, whether the CAA happens to be a subtle mechanism to exclude certain communities from the legitimate canvas of the Indian tapestry, so to speak. I've had all sorts of questions being thrown at me. And whenever these questions are asked, there are certain underlying assumptions which, according to me, need to be addressed, because these underlying assumptions are disturbing from let's say, a civilization standpoint, but more importantly, from a constitutional standpoint, for a different reason. Because we seem to be imposing our notions of the Constitution on the text of the document itself, as opposed to applying, let's say, our filters based on the history of the document. So the issue of citizenship is part of Part 2 of the Constitution, as everyone's aware of, and Articles 5 to 11 are the provisions of the Constitution which specifically deal with this particular issue. Now, to the best of my limited understanding, and I'm happy to be corrected on this particular front, I don't think there is any specific chapter of the Constitution that deals with the issue of refugeeship specifically, or any provision that deals with the aspect of which government or which entity shall bestow the status of refugees on people who qualify for that particular criteria. What is the definition of refugees? And there is no provision that deals with it. So there are certain entries of the Constitution which effectively vest the central government or the union government with exclusive powers with respect to matters of ingress and egress as far as the borders of India are concerned. So when you look at the issue from the standpoint of Constitution, the reference points, according to me, should be Articles 5 to 11, plus the silence in the Constitution with respect to refugees, and the provision of the Constitution or the entry of the union list, which allows the central government to have exclusive say as well as sway on the issue of who can enter this country and who can exit this country, what are those circumstances. Therefore, this is something that we must be aware of. that these are the relevant markers within the document that we have to look out for. Now, what is important about Articles 5 to 11 is that Articles 5 to 10 largely deal with the definition of who constitutes a citizen, and it also spells out the timelines or the cutoff dates for someone to qualify as an Indian citizen. And most importantly, there is a certain ethnic character which comes through the provisions of Articles 5 to 10, because you're supposed to establish your relationship with your ancestors who should have lived in this country before a certain cutoff date in order for you to qualify as an Indian citizen. Now, this is with respect to Articles 5 to 10, and in that you have certain provisions which deal with certain transitory or transient aspects, which is how does India deal with certain people who went from India to Pakistan after the partition and came back from Pakistan? How are they supposed to be treated within the four corners of the Indian Constitution? These are certain aspects that the provisions deal with. Now, with respect to a future citizenship law or an act, the relevant provision has to be Article 11, because it effectively leaves it to the discretion of the Parliament, the central legislature or the union legislature, to craft a law which addresses this issue and leaves it entirely to the discretion of the Parliament to put together a legislation that addresses the question of citizenship, which defines who is a citizen, which identifies what the criteria should be. Now, the question that we must ask at this stage is, can Article 11 of the Constitution be interpreted in such a way that the Union Parliament has such all-encompassing powers and overriding powers which allow the Parliament to draft a citizenship law which is completely at loggerheads with the rest of the Constitution or with the rest of the provisions of the chapter which deals with citizenship, namely Part 2 of the Constitution. Here it becomes relevant to actually even look at the Constituent Assembly debates on this particular issue. And if you look at the discussions going back to 1948 and 1949, there is a significant amount of discussion with respect to those communities who were rendered minorities within the newly formed state or the country of Pakistan, especially the Hindus and Sikhs of Pakistan. And the question that was asked was, should these people want to come back as a consequence of the religious character of Pakistan, which could have a bearing on their security, which could have a bearing on their ability to live in their country with dignity and safety? Shouldn't India welcome them back? And shouldn't India be the natural home that they are given access to as and when they wish to come? So when this discussion goes on, I'm not looking at what Mr. Mohandas Karamchand Gandhi said, because he was not a member of the parliament. Therefore, I'm not taking into account his opinions at this stage. He spoke as a politician. Therefore, what he said as a politician perhaps has very little impact when it comes to constitutional provisions. So I'm merely looking at the Constituent Assembly debates on this particular issue. My reading of these debates actually tells me, and it's not something that I'm trying to impute any value or impute more meaning to the Constituent Assembly debates than the language warrants. The express terms and the language in which these discussions happened were with respect to two communities and largely religious minorities within the state of Pakistan, who were expected to face marginalization over a period of time because of the mental character of Pakistan and the ingrained theory of the two-nation theory within the mental fabric of Pakistan, which they believed would ultimately lead to a situation where religious minorities would find it increasingly suffocating to live in that particular country. Now, whether these were apprehensions or whether these were prophetic anticipations, I think history has effectively proven them right over the last 60 to 70 years. And the reducing, let's say, status of their rights, the decline in their populations, the number of reports that have been issued both by civil society organizations from within that country and its offspring, which is Bangladesh post 1971, the number of reports issued by Amnesty International and other organizations with respect to the status of religious minorities, specifically religious minorities within Pakistan, makes it imperative for us to ask these questions as to whether what was said in 1948 has come true over the last 70 years. If that is the case, does India have an obligation? If so, is the nature of the obligation civilizational? Is the nature of the obligation religious? Is the nature of the obligation constitutional? is the nature of the obligation social, political, or humanitarian? These are the different levels at which this question must be asked. My sense is that India's obligation is civilizational, and through the constitution, that particular civilizational obligation has already been given effect to, if you look at the Constituent Assembly debates. And the kind of freedom that is being given under Article 11 to the Parliament is partly to address these exigencies and contingencies as and when they arise. So one of the reasons why the Parliament was given this kind of discretion to craft a future Citizenship Act is for it to be able to give access to such communities at some point. And most importantly, I think the question of refugees and the absence of a refugee-specific legislation is largely to be able to give the central government enough leeway to treat each of these groups or individuals on a case-to-case basis, so that multiple filters that the central government may want to apply, the security filter, the demographic filter, and other filters, before it allows a certain group or an individual within the borders of India, it is in a position to apply those filters. So this is the extent of discretion that is being given to the Parliament. In fact, there are multiple judgments of the Supreme Court on this particular issue, which specifically say that in matters of ingress and egress, the central government has perhaps the maximum extent of discretion or executive prerogative is possible to put it in the parliaments of the constitution. And therefore, from subject to subject, the extent to which Article 14 is applied must also vary, because that depends on the extent of prerogative that the executive enjoys with respect to a given subject. So for instance, with respect to Part 3 of the Constitution that relates to fundamental rights, assume for a moment that the executive has the prerogative of a circle of diameter X. When it comes to the Part 2 of the Constitution, namely aspects relating to citizenship, not only the Constitution, but its interpretation by the Supreme Court makes it abundantly clear that the extent of participation, also the extent of prerogative available to the executive is X plus plus. Okay, which effectively translates to reduced answerability or accountability. I'm not saying that's not dangerous. I'm not saying that's without consequence. I'm merely setting out the position of the Constitution on that particular issue to effectively say that when you approach the issue of citizenship, you must consider the fact, and I'm not saying the opinion, you must consider the fact that the Constitution cedes more space to the executive and the parliament than to the judiciary. And therefore, the extent to which judicial review can be undertaken with respect to matters of citizenship and refugeeship is significantly lesser, or the scope of consideration is smaller compared to other issues. Which is why when somebody asks me about Article 14 and its application of principles of equality to the question of citizenship or refugeeship, my first reaction has always been to point out that when you look at these aspects, please look at the subject to which you choose to apply or you wish to apply the filter of Article 14. And that's something that I think has been largely lost on, let's say, popular discourse or political discourse. So it takes a bit of understanding of the Constitution to make this point. But for a moment, let's leave the Constitution and its technicality aside and address it from a high-level perspective. A sovereign state has the right to decide who can exit or enter its borders, who can exit from and enter into its borders. That is a right which is incidental, which flows as a corollary to its status as a sovereign state. Therefore, these assumptions which effectively surround Article 14 forget the fundamental right or power that a state derives from its status as of being a sovereign state. That is, it decides who gets to violate its borders or who gets to respect its borders, or how to maintain the sanctity of its borders. And maintaining the sanctity of the borders is not just with respect to the territorial integrity of the country, but also the demographic integrity of the country, but also with respect to the composition of the country. To ask whether a certain group or an individual who enters the country poses a threat to any significant group or legitimate group of citizens or even individuals within the country. That's a question that every country, by virtue of being a sovereign state, has the right to ask. Whether that state is a nation state or a civilization state does not make a difference at all. So this is something that I think has fundamentally been misunderstood in this entire discussion, because almost every discussion surrounding this particular issue starts with Article 14 and ends with Article 14 without asking the basic question: what is the extent of prerogative or discretion that is being given to the central government as well as the parliament by the constitution with respect to this specific issue? Unless that fundamental issue or that foundational building block is understood with clarity, the imposition of any filter such as Article 14 or any other constitutional filter really does not make any sense. Now, let's go a step further and ask which are the relevant legislations which apply to this broader discussion. You're looking at the Citizenship Act, you're looking at the Foreigners Act, and you're looking at specific provisions of the Citizenship Act under which rules may be formulated with respect to NRC and NPR. So the citizenship rules of 2003, which effectively deal with NRC and NPR, are pursuant to a specific provision of the Citizenship Act. Now, what does the Citizenship Act cover and what does the Foreigners Act cover? Why do we need both these legislations? Now, the Foreigners Act is a colonial legislation of 1946, which came into existence well before the Constitution came into existence. Whereas the Citizenship Act owes its origins and owes its life, so to speak, to Article 11 of the Constitution. Therefore, it has come after the Constitution in the year 1955. Now, the term citizen effectively has been defined in a slightly negative fashion, which is to say that those who are not foreigners are citizens within the meaning of the Citizenship Act. And I think it's possible for people to take a look at the definition. Please take a look at that, and you'll see for yourself the slightly tautologous fashion in which citizenship has been defined. Now, who is a foreigner for the purposes of the Foreigners Act? Effectively says that someone who enters this country without valid documents, or someone who overstays his welcome, which is to say that if he was given a specific period for stay within this particular country, and he chooses to stay in this country beyond that particular period, then effectively his documents which are previously valid become invalid at a certain point of time, rendering the person a foreigner for the purposes of the Foreigners Act. Now, what we must also understand is we don't have a definition for refugee. We have only definitions for illegal migrants, we have definitions for foreigners, and we have definitions for citizens. Therefore, the concept of refugeeship does not have a statutory codification as far as India is concerned. And that has been largely the preserve of the central government based on a notification or a standard operating procedure issued, I think, on the 29th of December 2011 by the Ministry of Home Affairs, which effectively allows the central government to take up the case of refugeeship on a case-to-case basis for a significant period of time during, let's say, under independent India or in independent India. The aspect of refugeeship has always been decided in consultation with the UNHCR, where we go by the recommendations of that particular body, so to speak, with respect to who qualifies as a refugee. And in addition to that, we apply our security filters asking whether the entry of a certain group or an individual into this country poses a threat to the country's fabric in any manner, or are we inviting antisocial elements into this country under the garb of rehabilitating or settling refugees. So this is something that we have to understand, that there is no definition, there is no statutory codification with respect to refugeeship. Now, what does this ultimately translate to? Does it mean that merely because we don't have a law with respect to refugees, we can be entirely arbitrary and whimsical in the manner in which we bestow that particular status on certain groups or individuals? Can these identities be bestowed in a group fashion, or are they necessarily to be bestowed in an individual fashion? What is the level of analysis? How granular is it supposed to be? That's a question that needs to be answered. Second, can India operate with respect to the question of refugeeship completely independent of the international instruments and international law on this particular issue? That's another level of the argument that needs to be addressed. Now, there are multiple conventions and international instruments that deal with the aspect of refugeeship and their rights. What is to be taken as their de minimis rights, which every civilized nation which belongs to the community of nations is expected to respect under any circumstances. Now you have the New York Convention, you have the United Nations instrument with respect to refugees of 1951. Then there's the Protocol of 1967, which is a follow-up to the 1951 instrument. Now, each of these international instruments recognizes that refugees, no matter where they come from, must be treated with dignity and must be given the basic treatment that every human being deserves as a person. But they are not expected to be bestowed or blessed with the same level of rights as a citizen. And that's precisely why when you look at the Supreme Court's interpretation with respect to the rights available to refugees once they enter the borders of India, the Supreme Court has said that no person who is not a citizen of this country has the right to be treated at par with citizens insofar as their right to stay within this country is concerned, because that is effectively a decision to be made by the executive, taking into account multiple considerations. Second, there are judgments where the court has even interpreted Article 19 and the right to free movement under Article 19 to basically say that even the right to free movement within this country is subject to reasonable restrictions that the government may impose either through law or let's say any form of law. And the court has interpreted this to mean this is not just right to movement within the country, it also impacts the right to entry into India and the right to exit from India. That is the expansive interpretation that this provision of the Constitution has effectively been given by the Supreme Court. And the Supreme Court has effectively considered those entries of the Constitution which relate to ingress and egress to basically say, look at the level of latitude and look at the level of discretion that the framers of the Constitution have given the central government and the parliament with respect to ingress and egress. And therefore, no one in this country can say that their right to free movement is complete and absolute and is unfettered. The reason why this is also important is that the Constitution promises to retain the demographic composition of certain parts of the country, especially in the Northeast, to ensure that people from the rest of the country do not alter the demographic composition of those places, because that's the condition on the basis of which those parts which were previously the princely states or other states ceded and they became part of the Indian Union. So these are multiple considerations. So those rights which are not available to Indian citizens with respect to movement within the country cannot automatically become available to foreigners or people those who are not citizens. So that's the central understanding that I think is important, along with the understanding of Articles 5 to 10. 3, I think what is also important to note is that these very international instruments that deal with the rights of refugees clearly spell out that countries have the right to look out for their security considerations, national security considerations, safety considerations in applying each of these principles. And they are not under obligation to invite or rehabilitate or settle every group whose fundamental worldview is at loggerheads with that of the country or a significant cross-section of its population. So there is a principle which is recognized in international law in the context of the rights of refugees, which is the principle of non-refoulement. So let me give a simple example. Assume for a moment that there is a community which comes from Burma into India on the ground that the community is being persecuted as a community and not just individuals because of its religious affiliation or cultural affiliation or whatever it may be. Then its neighboring countries such as India, into which these groups may come into, have the obligation to not push them back to the very country where they're being persecuted, which is to say, you can't send them back to the very crucible of persecution which they are trying to escape. That is the fundamental principle of non-refoulement. Therefore, the requirement to not push them back into those jurisdictions doesn't translate to an obligation to make them your citizens. That is the fundamental disconnect, I think, in our understanding. You can't push them back into their countries because you're effectively asking them to surrender to death or persecution, which is something that goes against the concept of human rights and which goes against the concept of humanitarian treatment. But that doesn't necessarily translate to an obligation on this country, on the host country, to give them the status of citizens or bestow them with the same rights as citizens. This is the fundamental issue that I think that also needs to be understood along with other foundational premises. So what is the obligation that India has when it comes to refugees, should it not want to give them the status of citizens? India can continue to give them work permits if it chooses to, if it believes that they have a certain degree of security clearance, and that they do not want to give them the status of citizens until they have been tried and tested, so to speak, and their behavior as a community is clear to the Indian government. Until it is clear to the Indian government that these people have not been sent to act as puppets of a foreign state and they're not pushing the vested interest of a foreign state or a foreign entity or a foreign group. These are aspects that the Indian government has the right to consider, and therefore you have a significant period of time that these people are expected to stay in this country before they become entitled to any kind of a status. Okay. And the other thing that the country also has the right to ask itself, when it chooses to host them as refugees also, is that they have to qualify to the elevated definition of refugees, which goes well beyond the definition of an illegal migrant. So as I said earlier, if Indian legal framework only recognizes the concept of a foreigner, a citizen, and an illegal migrant, what is it about a refugee or the concept of a refugee ship which distinguishes it from all other definitions? So everyone who enters this country without a valid document or without permission into the borders of India, by default becomes an illegal migrant because he has entered this country without valid documents. That's the broad definition. Now, from being an illegal migrant to making the transition to the status of a refugee, you need to satisfy certain definitions. The universally accepted definition of a refugee is that there must be an element of persecution which is involved, which is to say that persecution is the reason that you have chosen to leave your country of birth or your country of residence, and you've chosen to come to this country and you've fled that country. That persecution could be based on grounds of religion, it could be based on grounds of sexuality, it could be based on grounds of culture, it could be based on multiple reasons, ethnic reasons. So each of these reasons, the underlying thread or the common sentiment is the element of persecution. So not every illegal migrant translates to or gets access to this definition of a refugee. He does not qualify to become a refugee. For you to constitute a refugee, the situation must be more dire. You must seek asylum. You must seek shelter. Seek shelter. If you come to this country merely because it presents better economic opportunities, or because your country is overflowing with people and therefore you need to go to a country which is less crowded, which presents you with more options, you don't become a refugee under any circumstances. That is not a case of economic persecution. That is a case of economic depression, perhaps, or lack of options. Therefore, no person who chooses to go to America because there are greener pastures to be graced upon in America translates to a refugee. Going by the definition, every person who leaves India to go to America because there are better opportunities for him, he will immediately qualify for the definition of a refugee. That's not how it works. Therefore, when we apply the term refugee and when we choose to bestow that particular status either on an individual or a group, we must be extremely careful in understanding this definition and in applying the definition. That is something that distinguishes it significantly from the concept and the definition of a citizen, an illegal migrant, and a foreigner. This is something that I think bears repetition. Now, the other thing that needs to be understood is if there is no definition for refugees and there is no refugee law in India, so to speak, or there is no specific statute which codifies each of these aspects, what stops the Indian government from acting whimsically or arbitrarily with respect to vestation of the status of refugeeship or giving refugees the status of long-term migrants, or let's say long-term visas, or giving them the status of citizens at a later stage? What stops the Indian government from acting in an entirely partisan manner with respect to this particular issue? Frankly speaking, that is where judicial review becomes relevant to some extent, but not to the extent that we understand it. So let's take the example of Assam and the case of illegal migration into Assam. if people were to read the judgments relating to the Assam Accord and the Sarvanand Sonowal line of decisions, where the Supreme Court was looking at the menace of illegal migration in Assam, one of the arguments that was presented on behalf of the Assamese people to protect their identity was that by facilitating the influx of migrants from Bangladesh into Assam and giving them the status of refugees, the Indian state was effectively in violation of Article 355 of the Indian Constitution, because it was violating the territorial integrity and the demographic integrity of that particular state, not just with respect to its borders, but also with respect to its composition. That was one of the central arguments that was presented on behalf of the petitioners in that case. And specifically, this argument, if I remember it right, was made in connection with the IMDb Act, which was the legislation then in place. I think in 1983 is when the legislation came out. The object of the legislation was to constitute a special tribunal, which was specifically dedicated to the state of Assam for the expulsion of illegal migrants from the state of Assam. So for the rest of the country, the Foreigners Act would apply for the purposes of expulsion of foreigners, but for the state of Assam alone, the IMDb Act of 1983 was brought about. And the challenge to that particular legislation was leveled on the grounds, or mounted on the grounds, that under the Foreigners Act, the onus is on a foreigner to prove why he must not be expelled, because it is for him to demonstrate that he has entered the country with bona fide documents, with valid documents. In stark contrast, under the IMDb Act, which was introduced with the ostensible purpose of expelling illegal migrants with greater expedition, because the state was brimming with illegal migrants and continues to brim with illegal migrants, in my opinion, the onus of proof, so to speak, was completely reversed, which is to say that it became the onus of the state to prove why a certain person was an illegal migrant. Therefore, the entire object behind the IMDb Act was defeated by the provisions of the IMDb Act. And therefore, the court effectively said that the Indian state had promised to protect the ethnic identity of Assam from any kind of demographic invasion, and had brought about this legislation with that specific intent, but the language and the express provision and the mechanism under the Act went counter and was at loggerheads with what was promised to the Assamese. It was on this basis that the legislation was struck down by a judgment of the Supreme Court in 2005. So whenever the government acts in a manner which is inimical to the interests of the natural denizens, or the, let's say, the people of a particular state who are its citizens, and they have a right to protect their cultural rights, they have a right to protect their religious rights, they have a right to protect their ethnic rights, by approaching the court and pointing out the fact that the center has abandoned its obligation to protect all forms of integrity of the country. So that's one. Second, what if the state has a religious filter in applying or rather in granting the status of refugees, refugee status, or even in granting citizenship to people? Now that, I think, is the most important question that needs to be addressed. Can a country which does not have a religious identity of its own apply filters based on religion? Now that's a very broad question, and I think that question lacks refinement for multiple reasons. If religion is being applied as a filter, is it being applied as a filter because religion is the basis of persecution of a particular group? In which case, application of religion as a filter is justified for a single reason, that the persecution is based on religion. Second, is it incumbent upon any state, any sovereign state, to treat all groups coming from outside at par with each other and to give them equal treatment? To my limited understanding of the law of refugeeship, the understanding of what are the powers of a sovereign state, and also India's rights with respect to citizenship, I don't think India, I don't wish to speak for any other country, India as a sovereign state, given the specific historical backdrop of its birth in 1947, upon the brutal and the bloody application of the two-nation theory, has the right and the duty to be very, very conscious of the kind of groups that it wants to give access to, either by way of granting them the status of refugees or granting them citizenship. Okay. Therefore, as opposed to making a broad statement with respect to every state, I'm making a qualified statement with respect to India, because the application of the Constitution, the reading of the Constitution and the application of the law cannot be divorced from history altogether, because the Constitution itself is a product of history and it is informed by significant milestones of history. Therefore, it makes very little sense to basically say, let's turn a blind eye to everything that has happened and open our doors to everybody under the sun, regardless of where they come from and what their intentions may be, merely because that is the mandate of Article 14. One, that is not the mandate of Article 14. Article 14's application with respect to the question of citizenship, Part 2, refugeeship, and any other status is limited significantly by executive prerogative, as I mentioned earlier. Second, let's address the question of the specific groups and the countries which are the beneficiaries of the Citizenship Amendment Act of 2019. 6 specific groups identified on the basis of religion have been given a certain benefit from 3 countries having an identified religious identity, either constitutional or otherwise. And in this case, constitutional, these are Islamic republics for all practical purposes. Now, the fundamental allegation or charge against the CAA is that, why have you given this benefit only to 6 communities on the basis of religion? Why not to every community from these 3 countries? That's the basic argument. Now, before we get further into that, let me first identify what is that specific benefit that is given under the Citizenship Amendment Act of 2019. What is that so-called benefit? Who are the beneficiaries? Who are the non-beneficiaries? And does it affect any of the group? Is the first question that I would like to address. Under the 3rd schedule to the Citizenship Act, certain requirements have been spelled out with respect to the number of years of residence a particular individual must spend in this country before their application for citizenship is taken up for processing, before it is taken up for consideration by the relevant ministry. Now, that period has been traditionally between 11 and 12 years. For the purposes of these specific groups, 6 communities coming from these 3 specific countries, that period has been limited to 5 years. That is the limited benefit that they get. And when they get that particular benefit, they will no longer be treated as illegal migrants. Any existing proceedings under the Foreigners Act for their deportation or expulsion will be seized immediately, and they will go through a natural process of abatement once these conditions are satisfied and once they get the status of citizens under the Citizenship Amendment Act. Now, I've had an opportunity to actually interact with some scholars who specifically deal with demographic studies, refugeeship, and citizenship, and I've had an opportunity to discuss these issues extensively with them. The problem is, and in fact, one of the scholars was honest enough to admit that he had misread the Act. If you look at the provision of the Citizenship Act, it specifically says that these groups shall get the status of citizens upon satisfaction of the requirements, upon satisfaction of the criteria, which shall be spelled out in the rules pursuant to the Citizenship Amendment Act of 2019. And once those criteria are satisfied and they're given the status of citizens, that is when the rest of the proceedings against them shall be abated and they shall no longer be treated as illegal migrants. The myth that has been perpetuated, according to me, in mainstream media and other places is that they have already become citizens and all existing proceedings against them under the Foreigners Act have been dropped. Anyone with basic skills of statutory interpretation, not even constitutional interpretation, has to merely go through the 3-page document which is known as the Citizenship Amendment Act and ask themselves, is this the consequence of the Citizenship Amendment Act? You read that along with the definition of an illegal migrant under the Foreigners Act and under the Citizenship Act, and you read all of these 3 together, you come to the clear conclusion that the only thing that has been done is that an exception or a proviso has been created to the definition of an illegal migrant under the Citizenship Act, okay? And that proviso shall kick in only after the satisfaction of the requirements that have been spelled out in the rules now. Okay. So assume for a moment that you have an application for citizenship that has been pending before the ministry for all these years. You will be entitled to the benefit under the Citizenship Act subject to the following conditions. That you must have entered this country before the 31st of December 2014, and you must have spent at least 5 years in this country. And the rules which have come about recently, which have been notified recently, must be satisfied before you can be granted the status of a citizen. After you have satisfied these conditions and you've been given that particular status, the proceedings against you which were initiated or which were sought to be initiated under the Foreigners Act for expulsion will be dropped. That's the basic structure or the framework or the flow of this particular legislation. Now, because this happens to be an amendment to the Citizenship Act, it has given enough fodder for, I would say, the usual suspects and the troublemongers to basically say, you have altered the definition of citizenship altogether because you've amended the Citizenship Act. That's not what has happened. Since you do not have a specific law that deals with refugees, the Citizenship Act is a limited intervention, rather the Citizenship Amendment Act is a limited intervention within the backdrop of the Citizenship Act to provide for certain conditions so that certain groups from certain countries can be given the status of citizens upon satisfaction of specified conditions. Therefore, the Citizenship Amendment Act for all practical purposes is a limited refugeeship act because you do not have a separate law for refugees. And since every country has the right to decide how it wishes to treat different groups with respect to the status of refugees, tomorrow if India wants to invite Ahmadiyas of Pakistan as refugees in this country, it is possible for it to amend the Citizenship Act once more to accommodate them as well. And nobody is saying that the Ahmadiyya Muslims of Pakistan or any other group in the neighborhood or anywhere else cannot apply. They can continue to apply and their applications will be processed on existing rules, which is to say that they will have to spend 11 to 12 years, as opposed to the benefit of 5 years that has been given to members of these 6 communities, namely Hindus, Sikhs, Parsis, Buddhists, Jains, and Christians from Pakistan, Bangladesh, and Afghanistan. That is the specific intent and that is the specific consequence of the Citizenship Amendment Act. Now, the confusion largely arises between the nexus that is sought to be drawn between the Citizenship Amendment Act and the NRC. The argument that has been made is that since political leaders of national stature have made the statement that the object of the Citizenship Act is to protect those who stand excluded from the NRC process, which was undertaken in Assam, where close to 1.9 million people stand excluded and 70 to 80% of them are Hindus from Bangladesh. The purpose of Citizenship Act is to protect them and exclude the Muslims who have come from Bangladesh, is the argument that has been made. Now, if the reference to religious identity offends people's sentiments, so be it. I can't help it. When you discuss this particular issue, I cannot not mention religious identities. I have no other option but to do so, because I think that's the bone of contention. That's the central issue here. Now, independent of the CAA and NRC, if you look at the 2 sets of groups that have come from Bangladesh and which have settled in Assam as illegal migrants for generations, both these groups have left Bangladesh for 2 different reasons. Merely because they come from Bangladesh doesn't mean that the reasons for leaving Bangladesh are identical between the 2 groups. It has been recognized in multiple reports that Hindus of Bangladesh have faced persecution for generations now because of their religious identity as a group, not just as individuals. Therefore, religious persecution aimed at a specific group based on their religious identity has been demonstrated factually. You cannot expect every individual of a particular group to demonstrate why he or she or how he or she has been persecuted religiously. Just as you don't ask questions with respect to caste discrimination in this country on an individual basis here, and you assume that on a group basis, you will have to assume religious persecution of religious minorities in 3 Islamic republics in our immediate neighborhood, thanks to the lingering effects and the lasting effects of the 2-nation theory and the mindset which continues to prevail in these countries. So I'll address the question of Afghanistan subsequently. Let me just address this question first, because two-nation theory is obviously not relevant to Afghanistan. It's only relevant to Pakistan and Bangladesh. Therefore, those people who belong to Hindu minorities of Bangladesh attract the definition of refugee for the purposes of treatment under the Citizenship Amendment Act, for the purposes of beneficial treatment under the Citizenship Amendment Act. And those who belong to the majority group of Pakistan or Bangladesh obviously don't constitute religious minorities for the purposes of those countries. Therefore, their exclusion from the scope of the CAA is driven by the fact and is based on the fact that they don't constitute religious minorities, and they certainly don't constitute persecuted religious minorities for the purposes of the CAA. Now, the next question then that becomes relevant is, can all those people who stand excluded from the NRC process of Assam or a national NRC which may be undertaken in the future become beneficiaries under the CAA? Impossible, because the Citizenship Amendment Act requires you to show that you have come from these three countries, requires you to be in this country before the 31st of December 2014. Assume for a moment that there is a Tamil Muslim from Coimbatore or Kadalur or some other place in Tamil Nadu who stands excluded as a consequence of the NRC at a future stage. And there's a Tamil Hindu who also gets excluded as a consequence of this of a future NRC at some stage. Could you please tell me which provision of the CAA allows the Hindu to become a citizen of this country and excludes the Muslim? Because neither of these two people will be in a position to establish that they are from either Pakistan or Bangladesh or Afghanistan, and neither of them will be able to establish that they fundamentally source their nationality to these countries. You have to understand that when people flee Pakistan, Afghanistan, or Bangladesh, they typically carry at least one document on the basis of which they are treated as citizens and nationals of these countries who are fleeing these countries. These are ground realities that most people are not aware of. Kindly take a look at several NGOs who have actually put out their facts with respect to people who are fleeing from Pakistan or Bangladesh. NGOs have been working with them. They at least carry their expired ration cards or their passports or some other document that has been issued by the governments of Pakistan or Bangladesh to establish that they come from that particular country. Okay. So the assumption that everyone or every Hindu who stands excluded as a consequence of the NRC in Assam or the NRC which may be undertaken at a nationwide scale in the future will automatically become the beneficiary of the CAA is at loggerheads with the express requirements of the CAA. Okay. Second, what do we know about a future NRC at this stage? We know nothing except for the fact that the cutoff date could be 1951. The cutoff date for the NRC which was undertaken in Assam was the 25th of March 1971, largely because of certain provisions of the Citizenship Act and as a consequence of the circumstances in which Bangladesh was born. But if you look at the ethnic Assamese demand, they have specifically said, why do you want to apply the filter of 1971 or the cutoff date of 1971 for Assam when the cutoff date for the rest of India is 1951? Is this not discriminatory? In fact, this is the subject of a specific writ petition that is pending before the Supreme Court, which was filed, I suspect, in 2012, where this specific question has been referred to a larger bench, wherein one of the issues that has been raised is under the Assam Accord, which was entered into between the Indian state and the All Assam Students Union as a representative of the Assamese people, was that the date which is relevant for the people of Assam and for the state of Assam is 1951, just as it is for the rest of the country. It's not 1966, it's not 1971. That's the argument. Therefore, the point I'm trying to make is, even with respect to Assam, the results or the outcome of the current NRC is not final because it is subject to the final judgment of the Supreme Court in the pending writ petition, which has challenged certain provisions of the Citizenship Act. Second, what most people don't even realize is that the rules of NRC with respect to Assam or in general have given or rather have specified multiple appellate mechanisms if somebody gets excluded as a consequence of the NRC process, either in Assam or in the rest of the country. Therefore, the point I'm trying to make is the NRC process has multiple stages to it. And even after the final list is released, once there is a collation of people who constitute legitimate citizens of this country, Those who stand excluded from the process as a consequence of the flaws in that particular process have multiple appellate mechanisms in order for them to establish that they are citizens of this country. So the three high-level myths that I'm trying to bust. One is that the Citizenship Amendment Act does not alter the metrics or the definition of existing citizens. It does not in any way affect minorities of this country or majority of this country with respect to citizenship. Not every person who stands excluded as a consequence of NRC Assam or NRC India at a later stage will be a beneficiary under the CAA. The NRC process is not a foolproof process in entirety, which is a different argument to be made altogether. But even if that process excludes someone, that process is not final. It is subject to multiple appellate mechanisms, which is why more than 300 to 400 tribunals have been established in Assam for all these 1.9 lakh people who have been excluded as a consequence of NRC to be able to make their case again as to why they should have been included in the final list. Okay. And we are not sure of the kind of documents that we would be expected to be, we would be expected to present as part of nationwide NRC. But if NRC Assam were to be some kind of an indication, the documents are those documents which most Indians would be expected to have. But for a moment, let me just leave this argument aside and come to a different issue altogether. Illegal migration as an issue has affected India for generations now. It is a silent threat that has been eating into the vitals of India at least since 1960s. Therefore, regardless of the cost of undertaking a nationwide NRC, I don't think there is any cost that is not worth paying with respect to the issue of national security, with respect to the issue of territorial integrity, with respect to the issue of demographic integrity. Therefore, India not just has the right, but has a solemn, sovereign, constitutional duty to undertake that exercise according to me. But the funny part is, rules with respect to NRC and the very concept of NRC and NPR have been around since 2003. But nobody has challenged these rules. Nobody has challenged their very existence on the grounds that they are unconstitutional or they're unsecular or they're anti-secular or they violate Article 14 or some other provision of the Constitution. So successive governments have introduced that particular provision, have chosen not to repeal that particular provision, have had multiple discussions on the floor of the parliament with respect to religious minorities. In fact, Mr. Prakash Karat in 2012, if I remember it right, under Mr. Manmohan Singh's government, has written a specific letter to Mr. Manmohan Singh, urging him to treat the Hindu minorities of Bangladesh as citizens of India. And he identifies as part of that letter the caste composition of Hindus who suffer religious persecution in Bangladesh and who form the bulk of the population. And he identifies and he comes to the conclusion they are largely SCs and STs. He in fact names those communities as well. And this particular letter is publicly available in the official organ or the mouthpiece of the CPI, which is publicly available. In fact, I've given links to that as well as part of my talks and as part of my articles on this particular issue. So apart from the issue of constitutionality, apart from the question of international law, I find this curiously convenient that something that everybody has taken for granted since 1948 has suddenly become an issue in 2019. So I have to ask myself this question: if this position is valid, if this position does it reek or smack of political opportunism? That's a question that we'll address later, or I don't think I need to address it. People can draw their own conclusions. But what is certainly important, I think, that can be asked as a question with respect to CAA is why has the cutoff date of 31st of December 2014 been specified? Why not before that? Okay, that is a legitimate question that people can ask. Why are only certain people entitled to this particular benefit? Now, perhaps the response of the government, and I don't know what the response of the government is on this particular issue, the response of the government could be that we have to draw some cutoff date at some stage. Some bright line has to be drawn, because there's no specific answer as to why 18 or 16 or 17 is the age of majority for certain things and why the age of 21 is the age of majority for certain things. So numerical cutoff dates in these aspects are largely arbitrary in nature because you cannot justify it beyond a point. Now, if one has to really ask uncomfortable questions of the dispensation, the questions should be, what is it that the central government has done to improve the conditions, the living conditions of existing refugees in India who live in Delhi, who live in Rajasthan and other places? Because in fact, last summer, in most of these refugee camps, there was no electricity, there was no water, and these people were living in inhuman, unsanitary conditions. Children and toddlers were living. I know this because I've actually worked with some of these NGOs. I've given them some advice to the best of my ability. I've tried to read up the work that they have done and to inform and educate myself on the conditions in which these people live. Therefore, if somebody wants to ask uncomfortable questions of this particular government, questions largely could be relating to two aspects. One, why this particular cutoff date? Perhaps there's a tentative answer, but I don't think there's a clear answer on that. Two, what is it that you have done to improve the conditions of these refugees who are already within the borders of this country and who live in conditions in which we would not let even animals live, okay? Especially in summer, the conditions that they live is horrible. In fact, it was reported widely in 2019. And several toddlers were affected with all sorts of infections, and those conditions are ripe for epidemics and pandemics. I don't even know the conditions that they must be living in the time of Corona at this point, because I don't think there is a state apparatus which actively looks out for their interests. So there is a 360-degree view, which I think is important. Anybody who reads the Constitution in isolation and certain provisions of the Constitution in isolation, perhaps may be a constitutionalist, but I would say is not being a constitutional realist in that particular sense, because you're truncating the scope of your analysis, which is bound to affect the conclusions that you come to. When you look at the issue of citizenship, it is impossible to not look at aspects of politics, aspects of religions, and other issues as well. If that is uncomfortable, so be it. I don't think as Indians who have had open discussions on all sorts of issues, which is our traditional way of dealing with issues, we should run away from anything that's uncomfortable. But at the very least, before we throw out opinions and we come to uninformed conclusions, it's important to read some of these aspects, to read the black letter of the law and certain aspects of politics before we come to these conclusions. So I'm open to questions now.
Mr. JK?
So I guess Sai was making a point about these immigrants, say foreigners and citizens, and there was no mention of refugee anywhere in the Constitution. So my question was with regards to Sri Lankan refugees or Tamil refugees in Tamil Nadu. Right. Okay, so I'm not sure in which bucket they would be filled into, and you know how the state. I guess we all know the politics that is going behind them. So how the Constitution, how the country should be handling them.
So sorry, this has been a question lingering in the minds of very many people, especially those in Tamil Nadu. Right. So I need an answer from your end.
Yes, sir. So since I'm a Tamilian myself, at least I can be accused of having an anti-Tamil prejudice. So therefore, let me try and address this to the best of my abilities. One, the question of Tamil refugeeship, according to me, is a valid question. And that effectively means that we are saying that these refugees also deserve to be treated or must be extended the same benefit as the rest of the communities from the CAA. Now, that is an argument which is not strictly an argument under Article 14 for a different reason, because I think what Mr. JK is trying to ask is that is it possible for the CAA to be challenged on grounds of under-inclusion because it does not specifically include certain other groups which otherwise have been at the receiving end of the same treatment that the Hindus or the 6 communities which have been identified are getting in these 3 Islamic republics. I understand the question. Now, on that particular issue, there are 2 levels of arguments. One, government has the right to come to the conclusion that post the end of the civil war in Sri Lanka, given that this government, or at least the Indian government, successive governments, have leaned heavily on Sri Lankan governments to ensure that the Tamils of Sri Lanka are not persecuted either on ethnic grounds or on religious grounds, the situation could have improved, warranting therefore a conclusion that perhaps they don't need to be extended the same benefit. However, the point I'm again going to make is that Sri Lankan Tamils are not excluded from the scope of citizenship of India. They are merely not part of the benefit that the CAA extends. Okay? Therefore, Sri Lankan Tamils can continue to apply for citizenship to India, and all the pre-existing parameters that have been applied with respect to the grant of citizenship will be applied to them. The question that therefore you're asking according to me, should be slightly different, which is, why is it that the expeditious treatment that is given to these 6 communities has not been extended to let's say, the Sri Lankan Tamils? Okay. The answer there perhaps lies in the fact that the situation in Sri Lanka is not as dire, and this is largely an executive decision that is taken based on its assessment of the situation there. And most importantly, if the situation worsens there, I don't see why India cannot take a similar decision and make a second amendment to include these groups as well as part of this particular Amendment Act. Now, the one thing here I must address, I must take an opportunity to use this question to address the larger issue here, is one of the things that the Supreme Court has said in the application of Article 14 is that even in issues other than citizenship, when a class is created for the purposes of extending a benefit, and when this aspect of intelligibility of the class is examined within the 4 corners of Article 14, the appreciation or analysis cannot be with mathematical precision. You cannot use a surgical knife to create a certain class, because there is always bound to be one class or some individual who stands excluded as a consequence of a specific criteria. That in itself does not render a certain form of classification arbitrary or unconstitutional. The fundamental test that the court is going to apply is those people who have been put together as part of a single class, is there a common thread which is underlying them? And is there a nexus between the criteria which has been identified for extending that benefit and the benefit that is sought to be extended to that particular group? Those are the 2 primary levels at which this question is asked. On the question of citizenship and on the application of Article 14, the extent of discretion, since it becomes even more, the government does not have the same constitutional obligation with respect to classification as it has with respect to others. Kindly do not mistake this for any insensitivity or apathy towards Sri Lankan Tamils. All I'm trying to say is that the backdrop in which the CAA has been drafted for these 6 communities is slightly different from the backdrop in which Sri Lankan Tamils are, let's say, entitled to a certain benefit. The CAA cannot be challenged on grounds of the fact that it does not include so-and-so communities from across the world. Because if that's the case, Tibetans, despite being given sanctuary in this particular country, are not beneficiaries of this particular legislation, right? Because the conclusion that the court has come to is, the conclusion that the government may have come to is, how many applications do we have of this particular category? How many applications of citizenship do we have from Sri Lanka of Tamils, that necessitating a critical mass and therefore their inclusion as part of the CAA? In fact, during these discussions, well before 2019, if you look at all these discussions surrounding the amendment to the CAA, even by the Parliamentary Standing Committee, the discussion with respect to Sri Lankan Tamils was raised primarily in the context of this ongoing civil war then. And the tone of these discussions, the frequency of these discussions significantly abated, and they reduced after the end of the civil war, when promises were made by the Sri Lankan government to the Indian government that it shall not allow any excesses to be committed against Sri Lankan Tamils, including any military excesses. But we all know what happened ultimately there with respect to certain members of the LTT. That's a different issue altogether. Therefore, these decisions are largely based on how many applications of a certain nature we have received.
Mr. Kochar?
Veerabhadra Rao Kuchurlakota. I
Yes.
hail from Andhra Pradesh, but basically residing in UK. We've been so liberal with people that we have to have an iron hammer now to do all this thing back to get it into the system. Do you agree with that, sir?
Sir, I don't know if I agree with that, but I understand the sentiment and the spirit of your question. My only problem is this. You see, what has happened is, I could be entirely wrong in my analysis. I could be completely off the radar in my analysis. So those who disagree with me are welcome to disagree with me in the spirit of free speech and expression and diversity of thought. I don't have a problem with that. In fact, I'm more than happy to take any uncomfortable question. The point I'm trying to make is, I think what has happened, at least in the last 15, 20 years, is that the concept of sovereignty has been diluted significantly, okay? And our understanding of sovereignty and our understanding of what is it that a sovereign state is expected to do, what is it that it can do, has been diluted radically. Therefore, today, in fact, during the course of these discussions on CAA, I have seen the most mind-numbingly stupid comparisons made. which is to basically say, if Indians can go to America and settle down, why can't others come to India? Please, can you compare the circumstance in which Indians go to America, the kind of stringent conditions that they're expected to satisfy before they even get employment there, before they're accepted for, let's say, to pursue their masters, and the kind of conditions that India is imposing in the most volatile of neighborhoods in the world with respect to those people who want to enter this country as refugees. I mean, are we really so blind that we don't even see what has happened to the demographic composition of Assam, to its ethnic composition, to its cultural identity? And if Assam, a state of the country, has the right to preserve its demographic composition and its demographic identity, I am asking myself this question: why doesn't that logic apply to the rest of India? What applies to the goose equally applies to the gander. So those assumptions that we take for granted with respect to either a Kashmir, to say that that specific identity of Kashmir needs to be protected from any kind of demographic invasion from within India, from the rest of India, we don't wish to extend the very same logic to the rest of India or to the whole of India. That makes really no sense to me. And whenever I've been asked this question with respect to Ahmadiyya, since you've raised this issue, let me also address it. People don't understand one thing. One, Ahmadiyyas not being treated as Muslims or at par with the rest of Muslims in Pakistan is an issue for the Islamic Republic of Pakistan to address, because they are not religious minorities for the purposes of India, because Ahmadiyyas are Muslims for non-Muslims. What they are treated as within the Muslim community is their problem, and that too within the Pakistani Muslim community. Second, when has India shut its doors to either even a Pakistani or an Afghan national merely because they happen to be Muslims? Anyone who's lived in Delhi will tell you that there are significant pockets of Delhi, such as Lajpat Nagar, where there is a significant Afghan population who fled this country when the civil war broke out there, and who fled this country when the Taliban came to power there. And India has not shut its doors even to them during the peak of the radicalization in Afghanistan. However, India has a right to review and revisit these positions because it believes that the neighborhood has become even more volatile thanks to increased radicalization. Is it anybody's case that religious radicalization in our immediate neighborhood has decreased since 1947 or has increased since 1947, especially after Mr. Zia-ul-Haq came to power in Pakistan? Their own historians, their own civil society members are clearly saying that the radicalization in Pakistan saw a marked point of inflection after Zia-ul-Haq came to power. Therefore, we must be alive to the realities of our neighborhood. This is one of the few, or rather, India is perhaps the most functional secular democracy in perhaps the most dysfunctional non-secular neighborhood in the world. We don't give enough credit for India at all. And we constantly seem to loathe this country for its values. We constantly seem to loathe this country for its identity. Therefore, I think we need to stop beating around the bush on this particular issue and specifically highlight the fact that Ahmadiyyas, when they make a case for equal treatment in Pakistan as Muslims in Pakistan, start with the statement that we are one of the founding communities of Pakistan because we were the founders of the two-nation theory. We contributed to the existence of this country. So if that is the stated position, you please go to websites even today which represent the voice of Ahmadiyyas in Pakistan. The opening page speaks of their contributions to it. Book after book written by credible, authentic historians points out to the role played by Ahmadiyya militias in the creation of the Pakistan through force, active use of force, and in persecution of non-Muslims. So if on one hand we are willing to recognize the concept of group persecution within India and other places, why is it that we are so reluctant to identify the fact that there is a group persecution of specific religious identities in these three Islamic republics as a consequence of group identities? This is something that we will constantly beat around the bush about, and we will constantly bury our heads in the sand as long as we do not read history. Any reading of the Constitution which is not supported by a reading of history, according to me, is an ahistoric reading of the Constitution and will always do injustice to the provisions of the Constitution and its intent. It will in fact pave way to a situation where the Constitution is used to create constitutional means to come out with unconstitutional outcomes and anti-national outcomes, dare I use the word. So I don't have a problem in saying that we need to be much more let's say, blunt and candid in our approach, but the solution is not an iron hammer. The solution is to use this particular opportunity to discuss a lot of things about history that we have been traditionally shying away from and running away from.
No,
The fact that the two-nation theory and the partition continues to be relevant in modern India in 2020 is something that is sad, but that is not something that India must be blamed for. That is something that the rest of the countries must be blamed for. I haven't seen too many voices which constantly praise Mr. Imran Khan, asking him the question, why is it that you're not able to treat your religious minorities properly? That is why India has had to come out with a CAA. Had you been treating your minorities properly, India would not need to come out with a CAA. People would not be rushing to this particular country. That's a question that we have not asked.
Mr. Gopi?
Yes, yeah.
Yes.
See, the opposition parties of India in the parliament, they support the CAA or they have they have walked out. But when it is being implemented, instead of going to the court, they instigate people and then make a mockery of the democracy in various parts of India. Thanks to Corona, that the whole thing got subsided. Now, I would like to have your comments, please.
Actually, it reflects very poorly on the union government, according to me, that it took a corona to actually address these riots. So a couple of months ago, this publication called The Quint reached out to me to ask me to write for them certain articles on different issues and all that. I had written one piece for Quint, I think 5 or 6 years ago. But then when I started seeing some of their positions and the manner in which they were painting the Indian armed forces or their positions with respect to Indian interests, I consciously chose not to write for them again. That's my position. I decided not to write for them again. When I told them bluntly that I'm sorry, I will not write for you for these reasons, they said, why, what is the problem? We are an open organization. We don't have a problem with any point of view. I said, I understand that, but I certainly have a problem with certain positions and I don't want to be associated with someone whose positions are so blatantly anti-national according to me. I've said this bluntly. Within a few weeks of me refusing to write for them, they ended up writing articles where they called me a stooge of the government. They called me an agent of the government. They called me a voice of the government. And this was in stark contrast. They said that people, Surit Parthasarathy is someone that I've had the opportunity to debate with. So contrasting his position with my position, they effectively said, Surit Parthasarathy has taken a position against the CAA and Sai Deepak, a supporter of the government, has taken a different position. What they did not realize is, my position was in support of the CAA despite its flaws. And I'm the person who's also questioned the government for not doing enough to improve the conditions of refugees who already exist in India. I am someone who's already taken a vocal position against the concept and the idea of a uniform civil code for my own reasons. So mine is an issue-based approach. Okay, that's something that most people have not realized. Second, I think what is also problematic is the government, according to me, sorely misses an articulate voice like Mr. Arun Jaitley in the moment of its need. Okay. Correct. And perhaps the government could have done its preparation better. See, I am not someone who constantly rails or rants against the government merely because it's fashionable to do so. Where it's possible and where it is justified, one must support the government. After all, that is what governments are for. If governments are constantly supposed to be our whipping boys, why on earth do we elect them? What is the point of having government in the first place? It cannot be the object of our emotional vent. It can't be our constant object of hatred, regardless of who it may be. If the CAA had been introduced by the previous dispensation, I would have supported it with equal vigor, because at the end of the day, it addresses a civilizational concern that has been pending since the independence. It is unfortunate that it takes this dispensation to address this particular issue. However, my criticism against this government has been its lack of preparation and the lack of clarity with which it has articulated its position with respect to this issue in public fora. I would have expected the government to anticipate these kind of riots, knowing what certain people have been waiting for, knowing what kind of political opportunity it represents to certain people to whip up passions. Because every discussion that I've had with sane members of communities across the board, they've asked, what is it about the CA that is instigating people? Because we can't seem to find anything in it that excludes us, that excludes anyone. In fact, my very first impromptu video on the CA, which was put out on this platform called Upward, I spelled out that I had to come out with that video because a practicing Muslim friend and advocate himself reached out to me to specifically say, Sai, I think there's a problem. My relatives are asking me if I'm supposed to be ready with documents, or if they're supposed to be ready with identification documents. Are we going to be thrown out of this country? So I had to ask him, where is this sense of fear coming from? You are a lawyer, you're a practicing lawyer, you've gone through the material. Please tell me where is it? He says, I understand this, but I think it's important for you to put out this video because you've been talking on these issues for quite some time. I've been speaking on illegal immigration since at least 2016-17. So that's the reason I came out with that video. And he even went to the extent of informing me that voices on the ground were generating this kind of paranoia, were generating this kind of hysteria, because for some reason they felt that no, we are going to be excluded. Perhaps the government could have played the optics issue better with respect to calling this a Citizenship Amendment Act, because anyone who does not read that particular document, like most people don't, is bound to assume that the metrics of citizenship and the definition of citizenship has been altered. When you simply read the title, Citizenship Amendment Act, what do you understand beyond the title? Nothing. Okay. That's it. So I think that optically, strategically, and on the ground, the government has not done enough. Its preparation was certainly not up to the mark. And if ultimately every issue of national importance has to be defended by the two central people in the government, then there is something seriously problematic with their ability to delegate. Okay, I've said this before and I say this again. I make no bones about the fact that there are legitimate criticisms that can be hurled against the government, but I don't think those are the ones that we are airing. We're airing everything that doesn't work.
Let me move to Mr. Hari Lal.
Hello, Saiji. My question is, what if Bangladesh is not willing to take their illegal migrants in India?
Brilliant, brilliant. That's a fantastic question. And this is something that I think is a question that effectively tries to understand that issue. So there is already a petition, sir, before the Supreme Court asking for deportation of illegal migrants across the board, regardless of their religion and all that. Now, the solution for this comes from two documents. Now, Lieutenant General S.K. Sinha's report of 1998, when he first highlighted the issue of illegal migration in Assam and the rest of the country to the then Prime Minister, to the then President K.R. Narayanan, has been rubbished by a lot of people because they find the truths in it, or at least his positions, uncomfortable. What is important is those positions and those concerns have been endorsed by the Supreme Court in its judgment of December 2014 in the case of Assam Sanmilit Mahasangh versus Union of India. Please read the judgment. Justice Rohinton Nariman and I think Justice Ranjan Gogoi were the ones to pass that particular judgment. Please see how the Supreme Court has narrated aspects with respect to illegal migration. Okay. Then whether some of these facts are merely facts used to indulge in spit and scoot politics, or whether it is basically facts which are being aired to tarnish a particular community, it will all become clear because these are judicially recorded facts. Now, coming to your question, the second document which makes it very important for it to be read is the 175th Law Commission report, where specific amendments to the Foreigners Act was discussed extensively, I think by Justice Reddy, Jeevan Reddy, I think, when Mr. Arun Jaitley was the law minister at that point. I think it was released on the 21st of September 2000, if my memory serves me right. That report addresses multiple issues with respect to the number of foreigners tribunals that the government needs to set up and the qualifications of the people who will manage those tribunals, and the creation of a separate task force or a separate body altogether to address the issue of illegal migration. Because if the beat police cop is supposed to address rape, murder, theft, and illegal migration, I think we're already overburdening the police force across the country. And it's already unfortunate to be a policeman in this country thanks to the kind of population that they have to deal with and the kind of circumstances that they have to operate under. In fact, I've said this once, that anybody who is a policeman in his current life must have done a lot of things in his past life, and he's going through a perpetual 7.5 according to me. Okay, so for him to also deal with the aspect of illegal migration is too much. The one thing that the report also says is, assume for a moment that the country of origin from where these people come refuses to take them back. There are two options. One, do not give them voting rights, no political rights, so that they don't become vote banks. Okay. Second, they will never have the power to purchase immovable property in this country, because immovable property is land, is equal to presence, and therefore that translates to occupation. They will be allowed to work and they'll have other rights, but they will not have the right to influence the political process of the country, nor will they have the right to purchase immovable property. These two specific solutions were identified both in the report of Justice, Lieutenant General S.K. Sinha, as well as the 175th Law Commission report. Now, the one thing that the government could have done to address the issue of illegal migration, apart from the NRC as well, is to perhaps work on and implement some of these suggestions, which is to increase the number of foreigners tribunals. My position for a very long time has been that it's not enough to have more foreigners tribunals in Assam alone, because illegal migration is now there in Kadalur, it is now there in Chennai, it is now there in Hyderabad, it is now there in Mumbai, it is there in all parts of the country, even in Bhopal, even in Nagpur, and all sorts of places. In fact, there were news reports of trainloads of people who were illegal Bangladeshis making their way all the way to Kerala. That is the southernmost part of the country that we have, which is impacted by illegal migration. Whenever somebody takes a position with respect to illegal migration, the charge is of xenophobia, the charge is of, let's say, some kind of religious phobia. Please understand, illegal migration takes away the livelihoods of the bottommost rung of the ladder, because those are the jobs that effectively go in the hands of illegal migrants who are willing to work at 30% of the wages of the Indian or the Indian citizen. You go to Goa of all the places, please ask from the locals who are the ones who sell vegetables and flowers these days, and they'll tell you they are not Indians at all. And they're not legitimate Indians also. They have not come through the legal route. We don't have a problem, and as a country, we shouldn't have a problem with legitimate migration. If Indians can go to other countries looking for greener pastures, others must be able to come to India looking for greener pastures. That's not the problem. If you come to India, come legitimately. If you come to India, come through the proper channels. That's a legitimate expectation that every country has the right to ask. Whether it is asked by a political party of a certain affiliation or not doesn't make a difference. I am asking this question as a citizen of this country who wants this country to survive and not go through a third wave of attrition or a second wave of attrition after 1947. Therefore, my interest is in ensuring that we remain who we are, a secular, diverse, democratic country which does not go through radicalization because of external factors and extraneous considerations.
Let me move to Mr. Nandakumar.
There is this constant criticism that the express or the immediate objective of CAA is to somehow, through the back door, provide some legitimacy to Hindus who have been excluded through the NRC in Assam.
Right. I've already addressed it to basically say that those Hindus who stand excluded from the NRC process in Assam will not automatically become entitled to the benefit under the CAA, because you have to prove a few things. Second, if you happen to be a Bangladeshi Hindu in Assam who stands excluded from the NRC process in Assam, and if you've come to this country before the 31st of December 2014, I'm going to proceed with the assumption, which is the basic assumption, that as a Hindu in Bangladesh, you're a persecuted minority. And if you have come to this country before the 31st of December 2014, and you have something to show that you're from Bangladesh, then you'll be entitled to the benefit of the CAA. Please understand that there could be a lot of people in the Bangladeshi Hindu community, or rather in the Hindu community, who've been excluded from the NRC process in Assam, who may not be in a position to show that they are from Bangladesh, who may not be in a position to show that they've been here before December 31st of 2014.
Correct.
They cannot automatically get the benefit of the CAA. Okay.
Right.
So the problem is public discourse is never comfortable with detail. Public discourse is as blunt and as superficial as it gets. Public discourse never hinges on anybody doing the actual reading of the document, which is why it's possible for a lot of people to get away with a lot of misrepresentation and misinformation. I could be accused of misrepresentation as well. Okay, I'm not saying that my presentation could not be free of errors. If there are any of those errors, please feel free to point them out to me, because I know for a fact that at least my errors are not intentional, they are not motivated or not deliberate. I have done my reading on this subject. I've been speaking on this subject. I've delivered at least 6 lectures on the subject in different places before different audiences. In fact, perhaps the most recent one, which I would request participants to take part in, or rather to watch, would be my debate with Professor Faizan Mustafa, the Dean or rather the Chancellor of Nalsar University, and Advocate Aman Wadud, on the question of whether the NRC should be implemented on a nationwide basis, where I address these questions before an audience which for the most part, perhaps did not share my point of view, but it was a brilliant audience because the audience was extremely open-minded. And I did my best to answer as many questions as possible and took perhaps the most difficult of questions or questions which could appear difficult to others. So please watch that. This happened in October 2019, October 15, 2019. There is a YouTube channel which is maintained by some of my friends.
I have it in my. I'll share with you guys.
Okay, thank you. So you can.
I have a follow-on question, Sai.
Yes.
Would you have any data with you which would say how many people that are outside of these 6 religions that may get excluded as on 31st December 2014 if CAA was applied? Are there people that are waiting to get the citizenship who could get excluded on that day?
How many people from other religions from these 3 countries who stand excluded as a consequence of the cutoff date? That's your question.
Correct. Other than these 6 categories.
Right, sir. I must plead ignorance. I don't have the data of the number of people who stand excluded from that particular process, sir. Because you see, that would take into account what kind of factors. Let me just explain. I think Mr. Abhinav Chandrachud, a practitioner from the High Court of Bombay and the son of Mr. D.Y. Chandrachud, Justice Chandrachud, in his talk effectively said atheists will stand excluded, LGBTQ communities will stand excluded, Ahmadiyya Muslims will stand excluded, and the Jews of Pakistan will stand excluded, so on and so forth. So the first point is anyone who feels that he is persecuted in Pakistan will stand excluded, and we don't know how many people feel persecuted in Pakistan. Okay, right. That's the beauty of the country. Okay, so I don't know how is it that we are in a position to arrive at a concrete figure of the number of people who are likely to feel persecuted in Pakistan for multiple reasons. Okay, so I don't think that figure is a reflection of the validity of the CAA or is a reflection of what India must do. India has an obligation with respect to certain communities for specific reasons, and it has an obligation to others, provided it is sure that they do not pose a threat to the population or to the majority of the population in terms of numbers. If that's not an issue that that sells, or if people find that too extreme a proposition to accept, I don't know what else to make of this. Unfortunately, the discussion around these issues has become so muddled with the filter of political correctness that even facts have to be filtered through this prism of political correctness. Correct. Okay, facts are facts. If they hurt you, you have to address your hurt sentiments. That means you do not have the guts and the spine and the gumption to tolerate facts. That's not the problem of the fact itself. That's a problem of your inability to see the reality as it exists.
Let me move to Mr. Shanak.
So my question is, I understood the religious aspect of the CAA NRC. Now there is also a case, some people in Bangladesh, like Tasleen Nasrin, is making a case that the atheists will not be included in this. But even if they want to come to India, as they are persecuted, so what are your comments on this?
So are you a law student?
No, I am not from a law background.
Okay, the reason why I asked that question is, if you paid attention to what I said for the last 1.5 hours or so, what I said was, they are excluded only from the benefit of the 5-year period. Okay, they are not excluded from applying to India. Atheists, anybody who wants to come to India, India's doors are open under the traditional channels which have existed for all these years. The exclusion that you speak of is the exclusion of the expeditious period of 5 years. That's the only thing that you're asking for. Okay. So it is possible for the government to come to the conclusion that some people deserve the expeditious process more than the others because their identities as their religious identities are the subject of greater persecution. When the government realizes, see, you have to understand, and let's just think of this. As a country, we have welcomed Jews before we were a constitutional secular state. Okay, we have welcomed Afghans after we have become a constitutional secular state. Okay, several Iranians have come to this country also after the Shah of Iran was deposed. Okay, so this country has continued its tradition of being open to people regardless of religious identities, whether or not it has been a constitutional state or a constitutional democratic state, because that is the latent character of the Indian society. Okay, we don't give enough credit for that particular character, but we are being told, welcome all and sundry, at the expense of your own existence, to the detriment of your own safety, knowing fully well that they come from certain parts or certain neighborhoods which have been premised on the existence of anti-Hindu sentiment. Please tell me that, in fact, Mr. Kapil Sibal made this statement on the floor of the parliament when the CAA was being discussed, that the two-nation theory had nothing to do with religion. I'm sorry, has he read the Lahore resolution? What I mean, when these people make these statements and luminaries like him make these statements, it makes us wonder which books of history are they actually reading to come to these conclusions. When Sir Syed effectively spoke of the two-nation theory in 1883, he specifically mentions religions. When Jinnah or Allama Iqbal or any of the people who are credited with the founding of the concept of Pakistan and the idea of Pakistan, and therefore erstwhile Bangladesh as well, or rather erstwhile East Pakistan, how can religion be completely excluded from this? There's a fantastic book written by Venkat Dhulipala on Pakistan. Please read that book. It's one of the most scholarly accounts of the mindset that created Pakistan and the mindset that continues to exist in Pakistan. In fact, I had a couple of geniuses tell me, Bangladesh is a friendly country. It's not the same as Pakistan. Please read the literature which captures the statements made by their ambassadors, statements made by their ministers, statements made by the founders of Bengali nationalism or Bengali Muslim nationalism, to be very, very specific, who came to the categorical conclusion that there is a concept called as Greater Bangladesh that must be given effect to at some stage. Just as Hyderabad is the unfinished business, and Hyderabad and Kashmir are unfinished business of Pakistan, Assam is the unfinished business of those who founded Bangladesh. Why would Bangladesh opt to be a part of Pakistan if it did not subscribe to the concept of two-nation theory? After its independence in 1971, Bangladesh did not want to become a part of India. It wanted to be an independent Islamic republic. Therefore, its subscription to the two-nation theory was valid in 1971, as valid as it was in 1947, and remains valid in 2020.
Mr. Arvind Srinivasan.
How can the dichotomy between secular in the preamble and the numerous non-secular provisions be resolved?
Now, on the question of secularism, let me first check with the moderator. Would it be okay for me to address this question, sir? Because it may not be, it's indirectly relevant, but not directly relevant. What would you suggest I do?
Yeah, you proceed.
Okay. So, see, the fundamental point is, I don't think we have understood the document called the Constitution as it existed on the 26th of January 1950, as adopted on the 26th of November 1949. Because to a significant extent, our understanding of the Constitution has been influenced by what has happened subsequently, and we haven't paid enough attention to what happened until then, leading to the coming into existence of the particular document. So, which is why, without revealing too much, I have been writing a series in the Daily Guardian, trying to address these very aspects under a column called The Indic Views. And for the last 5 weeks, I've been writing, trying to explain what is the nature of this particular document called the Constitution. And I will be addressing 5 to 6 headings as part of this series: secularism, majority-minority rights, gender, religious freedoms, citizenship, caste, and all the hot potatoes under the Constitution, which occupy national discourse and center stage on a regular basis. My reading of the book tells me that the insertion of the word secular as part of the preamble, I think as part of this Indira Gandhi's attempts in the 42nd Amendment, I think in 1976, is perhaps an aberration from the original intent of the framers of the Constitution. Not to say that we were not secular previously, but the reason why that word was junked, in fact, if you read the constitutional history, there were specific suggestions made by Professor K.T. Shah and others, who effectively said India must use the word secular as part of its constitutional provisions and declare that it's a secular state. The discussion goes to an extent where they say that this word is laced with so much of subjectivity that it is capable of being hijacked for political interests. And therefore, it is best that we don't use it, because the word secular, as we understand it today, has significant European connotations, whereas India's approach to religion is very different, where it has its own civilizational identity, which requires everybody to be treated fairly and equally. Therefore, my entire position has been that the document is much more of a civilizational document, not the militantly irreligious, let's say,
secular document that it has been made out to be by a lot of people. Please strike a distinction between the mindset that came to occupy power post the general elections of 1952, which is the Nehruvian mindset, and the nature of the document as it came into existence in 1950. My point is, secularism, when understood in the context of India, has to be understood differently. In fact, again, I'll use Mr. Abhinav Chandrachud because he made quite a few points in response to some of my points, and which are very useful. He did not see a conflict between United Kingdom's promise of equal treatment to all religions and the fact that United Kingdom has a specific identity which is religious in nature because the Anglican Church is the chief church of that particular country. Okay. Similarly, Germany has a specific religious Christian identity. Several countries in Europe, which we look up to to understand the idea of Western developed nations, are religious in their character. Okay, from a constitutional standpoint, from a mental makeup standpoint, that has not stopped us from seeing them as fair countries. So when India says, I need not have a religious identity, but I certainly have a civilizational identity, why is that constantly raising the hackles of these people? That clearly tells me that nobody wants the native to say that this is the origin of this land, this is the identity of this land, and this is the beating pulse of this land. I think this is a larger discourse and a larger discussion that's happening at the level of the society. The talk has already started. I'm sure it'll go even further. And in the coming days and years, we will see a sharpening of this discourse, and we will have to take a position. It's going to be impossible for us to be fence sitters in this particular discussion.
Harsha?
Sir, why do we need to specify a certain cutoff date for the refugees to come to India? Why not accept them because they're being persecuted and promulgate an international law where we stand for the persecuted minorities? Why doesn't this happen, sir?
So on the question of the cutoff date, I don't disagree with you, to be honest. And that's not my way of trying to agree with you without telling you that I agree with you. I do agree with you, okay? One of the criticisms that could be leveled, I'm not sure if that necessarily rises to the level of a constitutional infirmity in the CAA, but the cutoff date perhaps goes against the intent of including as many refugees as possible, even within that particular class of 6 communities from these 3 countries. Okay. And to the best of my reading, I haven't seen a justification for this cutoff date coming from the dispensation, either on the floor of the parliament or outside of it. Very few justifications which are valid and which are fairly reasonable have come out. My view is, why do we limit it to them? Because a lot of people have languished in this country for several years. And why that particular cutoff date? Why should that coincide with the year that this government came into power, which is 2014? So I do believe that these are certain aspects of the CAA which are worthy of being addressed and which must be addressed so that more people get the benefit of it. So I agree with you. I have no disagreements with you on that count.
Sir, a second question is, has the government failed to convince the people about the CAA entirely, sir? Because there's a lot of riots that are happening. So is it a fault of the government also?
See, I'm going to say that the government is partly at fault. See, look at it this way. I could be wrong and I could be a cynic when I make this statement. No matter how the government, no matter how much the government had prepared, and notwithstanding any degree of preparation, there was always going to be some kind of social and political disturbance as a consequence of the CAA. Okay? Because it presents a brilliant political opportunity for a lot of people who've been in political wilderness for some time now. Okay? But most importantly, it gives a lot of fodder, despite its best intentions, to those usual suspects who have been constantly working on the agenda of portraying India as an anti-minoritarian, majoritarian society and government. Okay, that's been in play for quite some time now. Okay, in academia, in let's say in popular culture and whatnot. In fact, the ongoing controversy surrounding Mr. George Floyd and the attempt to impose those parallels on Indian society as well is proof of the fact that we want to show India as a deeply racist, xenophobic, casteist and whatnot country and a society. So I think in light of this clear awareness, it was the government's obligation to protect India's reputation and dignity through solid preparation, through better optics, through better communication. That way, at the very least, the genuine fence sitters who were not clear about the implications of CAA, NRC, and NPR would have had access to these facts. Because mind you, these riots, according to me, don't entirely indicate the extent of support or lack of support to this legislation, because by and large, the majority has always been a silent majority. Therefore, wherever I have gone and wherever I have spoken to people and interacted with even students, even on campuses which are predominantly left of center, I've managed to reach out to the fence sitters and I've managed to tell them, please read before you hurl any of these allegations. And those students have been fairly open-minded in receiving my point of view. Ultimately, whether they agreed with me or not, I'm not in a position to say. So I do believe that the government could have done better, and the government should not have been so, I would say, lenient in its handling of the riots. To me, it doesn't make a difference whether you're a student or a pregnant student or you belong to a certain community. If you choose to vent your ire on public property, endanger people's lives, block access to arterial roads, if you use human shields and you use babies, then I'm sorry, then other ways must be found. Perhaps less violent ways and less use of force must be found. But people cannot be allowed to hold the entire country or the national capital of the country hostage like this. Okay. And I don't think there is any Indian government that has managed to shore up India's reputation as a country which respects the rule of law. Every government, regardless of the party that has held power, has only reinforced the negative stereotype that India is a soft state. It does not know how to uphold the rule of law, whether it comes to lynchings, whether it comes to, let's say, allowing people to hijack public property or allowing people to create ruckus in the name of whatever interest. So I equally hold this government responsible for its inability to handle this manner in a manner that I would have expected them to. So I'm with you on that point.
Kishya Saran?
So my first question is, how are you defining Hindus under the, so I know that the definition is not from all our personal laws because Sikhs, Jains, Buddhists are separate categories. But my question was, would atheists be included as Hindus? I mean, I would think yes, because traditionally they are included under Hinduism. So why has, Mr. Chandrachud made the argument that atheists have been excluded from the law? I would think that they are included.
No, Mr. Chandrachud is of the view that atheists of a different background who come from a non-Hindu background, okay, ought to have been included. I'm sure he wasn't referring to atheists who are Hindus, because Hindus include atheists. I don't think that's a problem at all.
Yeah.
Because you see, atheism is a matter of personal profession, whereas religion is a matter of birth. Okay. So what your certificate says ultimately, in terms of what you are as a religion when you were born, is effectively what we are governed by, not what you claim to be. So what stops a Hindu from saying that he's a practicing Muslim despite the fact that the certificate says he's a Hindu? So I don't think that's the issue. Second, can I try and address your question in a slightly academic fashion? I'm not being academic here, but I think this is a larger discussion. I think it's a fantastic question that you've raised. I think what we understand as Hinduism today, for the purposes of legality, is largely an approximation. Okay. And I don't think we understand the true breadth of that particular definition and its all-encompassing nature in many ways. I don't say that everybody who is born in India is a Hindu. I don't think that's a valid statement at all. That was the traditional assumption when there was no other culture or no other religious identity that was sharing space with the Sanatana Dharmic identity. Ideally, the concept of Hinduism should be traced to the Shad Darshanas, the 6 schools of philosophy, namely those schools of philosophy that see Vedas as the primary authority of truth and as the primary pramana, and those which reject the authority of the Vedas. Therefore, those Nirishwarvadi schools of thought also are dharmic schools of thought, but perhaps non-Vedic schools of thought. So look at it this way. Buddhism and Jainism effectively challenge the authority of the Vedas in significant ways. Okay. At least that's the popular assumption, subject to scholarly correction. That's my understanding of it. I could be entirely wrong. But they still fall within the dharmic fold and they are to be treated as Hindus according to me. In fact, Sikhs, Jains and Buddhists need not have been specifically mentioned in the CAA, according to me, going by the definition of Hindu under the Indian Constitution. Okay, but because you're looking at communities who are coming from other countries, therefore you're looking at religious identities in those countries. There is a decent chance that other countries may not be treating Buddhists, Sikhs, and Jains as part of the Hindu fold, and therefore this was necessitated. Second, atheists of Hindu origin, atheists of Sikh origin, Christian origin, Parsi origin, Jain origin, according to me, are equally covered by the CAA. His primary problem was, what about atheists who don't share these 6 religious markers as birth identities? Okay, that I think is a different issue altogether. I think that's where he was coming from. Some of his questions, some of his responses had very clear answers to them. In fact, I would recommend people to watch the PDF for a very different reason altogether, because Mr. Chandrachud also makes the point that those provisions of the Indian Constitution which deal with the aspect of citizenship are markedly unsecular in their character because of their pro-majority bias, according to him. Now, here's the funny part. If, according to you, the most cardinal aspect of the Constitution which relates to citizenship is unsecular in nature, what is the basis of your statement that there is no religious identity in the Indian Constitution? So when these people constantly say that the Constitution has no identity, it is a secular document, and also make the statement that the citizenship portions actually has a religious identity, aren't they speaking from both ends of their mouth? Aren't they actually saying stuff which is contradictory? So which is why my position is that the Constitution is a document, its religious identity, I dare say it, its cultural identity and its civilizational identity is, according to me, an abysmally understood topic. We have not done justice to it. There is not much scholarship on it. There is not much reading of it. And people have accepted everything that the Nehruvian dispensation and its mindset has pervaded over the last 60 to 70 years, which I reject strongly.
We'll go to Vikrant Raji.
Sir, my question is about the cost of NRC. A lot of questions regarding cost and the difficulty in implementing nationwide NRC is raised because it will need a lot of staff and lot of infrastructure also. Right. So what is your view on it?
I think I've said this before, that when it comes to national security, I don't think any expense must be spared. NRC and CAA and NPR, according to me, are integral elements of national security. That is my position. And I will not take a mercantile position on this particular issue. Contrary to popular perception, I don't come from an affluent background. I've come up through a lower middle class background. Therefore, I understand the value of money and I understand the value of resource. Okay. So for me to make the statement that it is important to spend a lot on the lock to keep the house safe is not an elitist statement. It is a statement that, according to me, every sane citizen of a sovereign state would make. No matter what the costs, it must be undertaken. However, the one thing that I categorically stated in my debate with Mr. Faizan Mustafa at Nalsar was that there are certain systemic let's say, drawbacks in the NRC process, which the process in NRC exposed. And unless those aspects are addressed, it is not possible or it should not be undertaken immediately. Because the one thing that NRC Assam fell prey to is that over the last 35 to 40 years, and at the very least in the last 20 years, multiple lobbies and rackets have existed which have been in the business of forging documents for illegal migrants. There is a well-oiled machinery that has been in existence for decades. And that has effectively defeated the process of NRC Assam. Okay. So as long as those rackets are not busted, as long as the government does not tackle those issues through which illegal migrants have been normalized by whoever is pampering them and whoever had a vested interest in cultivating a vote bank, I don't wish to name them. It is important that those aspects are addressed before a nationwide NRC is undertaken. Otherwise, NRC, as opposed to weeding out and deporting illegal migrants, will actually end up legalizing illegal migrants. In fact, that is one of the concerns that was aired even with respect to Aadhaar by the Parliamentary Standing Committee under the previous NDA government, when Mr. Yashwant Sinha, when he was still a member of that particular party, actually made these observations, saying Aadhaar could lead to greater normalization and legalization of illegal migrants in the country. Okay. And any number of news reports will tell you how Aadhaar cards have been forged and how many people from, let's say, the illegal migrant community have benefited from this active, well-oiled, organized forgery. So I do believe that regardless of the costs, in principle, I stand by the particular process, but that process must not be undertaken until these structural defects and these practical issues are addressed.
But there were some schemes like scholarship in which Buddhists, Sikhs, and Jains were deemed as minorities. So I think those schemes are still in existence. So isn't it a contradiction with the article in the Constitution?
See, one of the things that if you look at how state governments have treated the concept of minorities and how even the central government has treated minorities, there's a huge inconsistency. In fact, in one of my recent articles for the Open magazine, I'd written that the National Commission for Minorities was established under the National Commission for Minorities Act of 1992. And if you look at the notifications issued under that particular act, I think one was issued in early 90s and the other was issued in 2014. Jains have been included as national minorities in 2014 under that particular act as religious minorities, according to me. And I think that's at loggerheads with the all-encompassing definition of Hinduism. Second, the concept of minority in India has been reduced to religious minority when the Constitution itself speaks of linguistic minorities and international instruments speak of even ethnic, religious, cultural, and other forms of minorities. So with every passing dispensation, the definition and the idea of minorityhood has telescoped to one particular understanding and certain communities within the minorities, because I don't find any representation of Jews or Parsis in the Minority Commission. Just take a look at the composition of the Minority Commission and who has occupied the position of a Minority Welfare Minister ever since that particular ministry was established in January 2006. I don't think there's been any diversity in the appointment at all. So there's a lot of hypocrisy whenever we discuss the issue of minorities in this country. And I don't think there is any dispensation, any political organization, any political party that is free from this hypocrisy, because you see, at the end of the day, their commitment is only to political goals, not to either the truth or reality or consistency.
Sabir Ali Chauhan.
My question is that in India, there are Citizen Act already exists in India, and CAA is amended in Citizen Act. Question that whether it is necessity of nation, number one. Second, whether it is necessity of the third, whether necessity of these political parties specifically. Explain.
Right. Any decision that any political party takes, according to me, has a political incentive. Okay, so I won't even run away from that. Okay. So it makes very little sense to say that merely because this particular dispensation has taken a decision, it has done so in the interest of the people. Because you see, this is not the first year of the second term of this particular government. This is the 6th year of this particular government, according to me. Okay. And since 2014, this decision was not taken, despite the fact that it formed part of their manifesto before the 2014 elections. Okay. So in fact, in several of my talks, I lambasted the government for dragging its feet on these issues. Okay. Saying you made a certain promise before the election. Why is it taking you such a long time for you to actually implement some of those things? Because these are the things that people like me are interested in. I'm very blunt about it. These are aspects which I relate to. These are aspects that I'm concerned about, because I do believe that in India's neighborhood, other communities which don't enjoy or which don't share the religious identity of Pakistan, Afghanistan, or Bangladesh are severely disadvantaged because of their religious identities, because they don't have the same mentality as Bharat. They don't have the same open-mindedness of Bharat. Therefore, as their presence in those countries is, according to me, a legacy of the partition, and therefore India has both a civilizational duty and a social duty and a humanitarian duty, because this is the natural homeland for these people, because they were part of undivided Bharat, is my position. So my direct answer to your question is, for a moment, let me completely, remove which government is in power, regardless of which government is in power, regardless of what political benefit that they may derive from it. I am only interested in the benefit that these persecuted religious minorities get in those countries, and what is it that India owes to them. India does not owe an obligation to people living in Peru, or people living in Palestine, or people living in the Middle East, or people living in Central Asia. But it certainly has an obligation in the immediate neighborhood with which it has shared a relationship for thousands of years, and which has been a part of undivided India for millennia. Okay. So even if it translates to a political benefit to a party, I'm not interested in that particular benefit. I would actually ask myself the simple question: why has it taken them such a long time to take this particular decision? In the last 6 years of their existence in power, why have they not done enough to improve the conditions of refugees who are already within India? So the point I'm trying to make is, it's impossible for us to try and remove a political incentive from the decision of any political organization. That I don't think should be a reason to dismiss a certain decision altogether, as long as there are certain valid beneficiaries of that decision.
Mr. Viraj?
So my question is in regards to the future implementation of NRC.
Yes.
What would actually happen to those who are made stateless?
Right. So as part of the talk, I mentioned 2 or 3 aspects. So let me just repeat them for the sake of clarity. Okay.
Yeah.
The NRC process is a staggered process. Okay. So there is a preliminary list which is initially prepared, which then goes through a phase of consolidation. Between the preliminary list and the phase of consolidation, there are multiple opportunities given for people to point out the fact that they have been left out or excluded. And even after the consolidated list comes out, there is enough scope for people to challenge the final list on grounds of being excluded unfairly, or because their documents have not been considered. Let me address this issue at a slightly broader level. I don't think there is ever going to be any mechanism which is going to be entirely foolproof. Okay, particularly when you undertake an exercise in the nature of NRC at a nationwide scale of a country which is the 7th largest country in the world, with the largest population, according to me, in the world today. Okay, so that's always going to be an exercise that is fraught with a lot of flaws. However, at the very least, that particular process can be worked upon and they can be improved. You can constantly improve it. I understand that it's a question of affecting people's lives. I'm not in the least insensitive to it or ignorant of it. I'm not oblivious to that particular factor at all. However, had illegal migration not come to a point where it has today, where people constantly downplay its impact on India, people constantly downplay its impact on national security, perhaps I wouldn't have pushed for NRC so hard. But I'm pushing for it so hard because I have had an opportunity to read and I've had an opportunity to discuss this particular issue with people who are working on the ground. Therefore, it is my conscious belief that the process needs to be improved to reduce the room for human error, to reduce the room for human suffering. But in these decisions, when you operate at the level of a nation, or when you operate at the level of a subcontinent that passes off as a nation, you're bound to have a few uncomfortable and unpleasant outcomes. The choice before India is not good, best, and better. The choice before India, when it comes to this issue, is worst, worse, and bad. And I'm saying you have to opt for bad at this stage, because the scale of illegal migration, according to me, has only peaked with every passing year. Okay. The unfortunate problem is that whenever we discuss these issues, we don't ask ourselves, there is not a single organization in the world whose process is completely foolproof, regardless of the size of that organization. But we expect the country to have absolutely foolproof mechanisms when it is operating at this scale. I'm not saying that the expectation of having a foolproof mechanism is wrong or unreasonable, but you must be realistic about the fact that you can't expect this particular process and this particular mechanism to be an exception to all other mechanisms and all other human-made mechanisms. Since it's made by humans, since it's made for humans, there is bound to be a significant room for human error. The attempt must be to try and bridge that particular gap as much as possible. But that's no reason to junk and jettison the process and the idea of the process altogether.
Sai Deepak, I have one question in the chat box. I think it's threefold in nature.
Yes.
One Srimati advocate from Chennai. I'll just ask to read over the question, you can answer.
Yes.
Number one, Why there was at all a CAA, anti-CAA protest in Tamil Nadu, when it would not have affected the folks down south in any way? First question.
So, because I believe that the south of India or southern India is going through or has gone through a silent radicalization without us realizing it. I believe that it has been going on for at least since 1998. The pampering of radical sentiments to the detriment of India's national security by various political organizations is, according to me, is a huge contributing factor, which I think the next few generations will pay if they don't take a stand against it and they don't act on it. So I think it's high time that the politics of the South acquires a more sane hue. In particular, the politics of Tamil Nadu, according to me, leaves a lot to be desired. It is too busy celebrating actors as opposed to focusing on what matters.
Second question is, what about Assam? There was a protest rally, but the protest is valid because of the fact that the demographic situation of Assam is watered down.
Right. So I think Assam has a very legitimate grievance with respect to the CAA. I'm not saying it is entirely wrong, because Assam has fought to protect its Assamese identity, not just its religious identity, because I think the entire Barak Valley, from what I understand, has Bengalis, and it has a lot of both Hindus as well as Muslims. So Assamese primarily want to ensure that their Assamese identity is kept intact, or at least retained to the extent it is at this stage. Because there are a lot of regional politics involved there and a lot of regional sentiments involved there. And this is not limited only to Assam. If you talk to people from Manipur, or if you talk to people from Tripura, or you talk to people from Assam, their fear has always been that of domination of their identity by the Bengali identity. That's been their historic fear for a very long time. And regardless of the religion of the person who speaks Bengali, that's been their fear. Okay. I'm not saying something that's controversial. I'm merely stating something that has been reflected by scholarly literature on this particular issue. I'm standing on the shoulders of scholars to make these points. I've read those points, and therefore I'm in a position to make these points. So Assamese are worried about the fact that the normalization and legalization of illegal migrants or refugees through the CAA could lead to a greater dilution of the Assamese identity, which I think was the reason for the protests. But I think once the concept of the inner line permit and other issues were addressed by the MHA, to a significant extent, the protests in Assam died down. And when they realized that these protests were being hijacked by other interests in the name of Assamese, I think Assamese realized what the situation was ultimately leading to. So I don't deny the existence of protests. I don't deny the validity and legitimacy of those protests in Assam. I'm merely saying Assamese had the good sense to understand that certain vested interests and anti-Indian interests were riding on the coattails of their sentiments to effectively facilitate greater dilution of the Indian identity in the name of protecting the Assamese identity. Okay, so that's something that we must be conscious of. The unfortunate part is people who are not from the Northeast and people who are not from Assam have spoken more on this issue than people from Assam. I think it's important to get speakers from Assam to speak on this particular issue. It's condescending, according to me, and reminiscent of the Nehruvian era, where so-called mainland India constantly speaks for and on behalf of Northeast India. Northeast India is as much a part of India as any other state in India, and the Northeast has its own diverse identity. It's not one monolith. Therefore, we must encourage those voices, not encourage, we must hear those voices. Encouragement would be condescending and patronizing. We must hear them. In fact, I would recommend and I would request, sir, to consider getting an Assamese speaker to speak on these issues, who can share his or her views on the subject with the participants.
It's a really suggestion, Mr. I take it very seriously. It's a good suggestion.
Thank you.
And if that be the case, has not the CAA has violated the Assam Accord?
Thank you. That's a brilliant question. So in two debates and panel discussions, I've actually said CAA does not violate the Assam Accord directly because you see, it does not speak of residence and place of residence. It speaks of citizenship.
Citizenship.
Right? Therefore, it is possible for those people to be granted citizenship and to be rehabilitated and for that burden to be shared by different states. Okay? So I have said this before, that since the government at the center is formed by the BJP, why don't BJP ruled states step up to the occasion and share the burden of housing and rehabilitating all those people who would stand to benefit from the CAA? For instance, I think Rajasthan, regardless of which government it is, has been open to it because they have faced the brunt of influx of Pakistani Hindus from their western borders. Okay, so the answer lies in practical implementation of the CAA that does not point to a direct violation of the Assam Accord by the CAA. Okay, because nowhere does it say that those people who have been given this particular citizenship will have to continue staying in that particular part where they are there. Right? So that's something that is capable of being addressed.
And there is one more question in the chat box. If religious demography is the issue, what determines religious demography in Kashmir prior to 1947? And even post 47 also to some extent.
Fantastic question. In fact, again, I'm not bragging here. I had addressed this specific issue as part of my talk on 2nd of August, 3 days before the amendments of 370, arranged by Daksha Legal in Bangalore. And one of the things that I specifically said was, we constantly speak of Kashmiri sentiments, that's a handful of districts, but we don't speak of Ladakhi sentiments or Jammu sentiments. And when everybody wants to restore the status quo of Kashmir and that we have to effectively protect its demographic identity, why don't we speak of the fact that out of the 40 lakh people, that's the 4 million people who constituted the population of the princely state of Jammu and Kashmir, close to 26% was non-Muslim. Where has all that population gone today? Why is it that the population has effectively been diluted? When we speak of protecting the minority composition in the rest of India, what about the minority composition of Kashmir? One of the things that I even highlighted with respect to the permanent residentship status before August 5th, 2019, was that Uyghur Muslims from China and so many people were given residency and the status of permanent residence of Kashmir, whereas that status was actively denied to a lot of people, including people from the SC/ST community in Kashmir. Therefore, the autonomy of Kashmir, the autonomy which was vested through Article 370 and specifically through Article 35A, and the concept of permanent resident as a state subject was used to strengthen a specific religious identity. When people run away from it, facts stare in their faces when they say these things. Okay? And when we speak of Kashmiri sentiments, why don't we take into account the fact that Jammu and Ladakh has constantly complained of stepmotherly treatment at the hands of state governments as well as at the hands of central governments, because every government seems to be interested in pampering the most aggressive and belligerent and separatist of sentiments. Why not those people who want to be with India, who want to be a part of India, who want to thrive and prosper and flourish as part of India? Why does the Indian state not listen to people who think well for India and who want to be with India? It's almost as if the Indian state only responds to stone pelters and AK-47 wielders. That can't be the manner in which the Indian state operates.
This is a very sensational subject, and rather it is also subjudiced. So there are a lot of inhibitions in the mind of participants. What could be the nature of the deliberation? What could be the phraseology used by the resource person? How can the host, myself, is going to regulate the speech? Everything was writ large, but I'm very comfortable with the speech you have made. And I don't find anywhere you have hurt anybody, or I don't find any reason to think that people are not taken care of, and none of the aspects are missed by you. And the way in which you have taken the audience with you through the pages of the amendment to the CAA and the NPR and NCR is in fact commendable. I don't believe in flattery, I'm telling you on your face. And what is a soft but yet a firm deliberation is something very difficult. And the path you have undertaken and the way in which you have deliberated with determination, commitment, with what you believe to be right is something very appreciable. As I don't want to make any disclaimer, the session went on well, and the kudos to you for the reason that the interaction was so smooth and none of the questioners were left unattended, and all questions were answered, whatever answer you have in your mind, and that is the speciality of the session. And I thank you for the time and the effort you have taken and the deliberation you have given to us. And thanks a lot, Mr. Sai Deepak. On behalf of everybody, I thank you.
Thank you,
Thanks.
sir. I thank all the members of the participants for such a patient hearing, and for sir for giving me an opportunity to interact with all these people. Special thanks to my dear friend Suvidat for giving me an opportunity to speak on this platform. I hope I have done justice to your interest in this particular session. I've tried my best to answer questions to the best of my limited knowledge and abilities. If I have not, I'm happy to do so, because I will continue to speak and write on the subject in the coming days and months. So thank you, everyone. Thank you, sir.
So Suvidat, are you hearing me?
Yeah, I can hear you. I can hear you.
You can say a few words about what was the deliberation and your comments, please.
No, in fact, this topic is more sensational, and the right person we can't find better than Sai. So he is the right person. He has addressed in many forums. So therefore, and he has addressed all the aspects in a limited time frame. And those questions, I mean, from all these audience, they are also pertinent and very relevant. So therefore, we will look forward for some other questions in another session, probably with some other topic.
Sure, sir. Sure, sir. See, the webinar series is meant for a public opinion forum, and it is not meant for any single individual or single ideology or any single thing. Whoever is having an opinion, it is open to us, and the way in which things are being done so far has gone well, and this is also one of such program. Thanks for giving Sai to our program, Mr. Suvidat. Thank you.
I'll
Thanks,
take
sir. Yeah, let me sign off.